All right. All right, we'll start this over. Good morning. I'd like to call the Nevada Commission on Ethics meeting to order. First, we'll start with roll. Vice Chair Wallen here, or Chair Wallen here, Vice Chair Teller.
Here.
Commissioner Lowry.
Here.
Commissioner Moran.
Here.
Commissioner Olson.
Here.
Commissioner Scheer.
Here.
Commissioner Yin is excused, and I would like to personally welcome our newest Commissioner Scheer to our commission, and we are looking forward to working with you. So thank you for being here today.
Thank you.
For staff, we have Commission Counsel Jensen. Here. Executive Director Armstrong.
Here.
Associate Counsel Bassett. Here. Senior Legal Researcher Pfaff. Here. And Investigator Terry.
Here.
Okay. All right, please stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Right, item 2, public comment. I just want to note here for the public that we're going to open item number 6 for public comment again. So if you want to make comments right before we do item 6 or after we do item 6, you can, or you can go and make your comments now. Executive Director Armstrong, has the commission received any public comment?
The commission has not received any public comment in writing by mail or email prior to this meeting. I just checked, and then we also have some members of the public on Zoom, but they have not yet indicated if they would like to make public comment. If they do, I'll let you know.
Okay. And there's no members of the public that are here that want to make comment, right? Okay. All right, great. Next item, approval of the October 18th, 2023 commission minutes. Commissioner Moran attended most of the meeting, so I will leave it up to you if you feel you should vote on this item or if you should abstain since you missed items after you left item 8. Are there any additions or changes to the minutes as read? All right, I'll entertain a motion to approve.
I move to approve the minutes as presented.
Is there a second?
I second.
Okay. All right. All those in favor? Say aye.
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 Aye. Opposed? Motion carried.
Yeah, please show me as abstaining since I was not at the meeting, Madam Chair.
All right. Thank you.
Thank you.
Next item. Yeah, thank you. Next item is approval of the October 18th, 2023 Personnel Subcommittee minutes. This item should be voted on only by the subcommittee members, which consist of Chair Wallen, Vice Chair Toller, and our previous Commissioner Dufferin. So Vice Chair Teller, are there any additions or corrections to the minutes that you see?
No, not that I see.
All right. I'll call for a motion
I move to approve the minutes as presented.
and I'll second. All right. All those in favor say aye.
Aye.
Aye. Opposed? Motion carries. All right. Next item is item 5. And today we are fortunate to have a presentation by Nye County on Nye County government. And I would like to ask County Manager Tim Sutton to please come forward and make your presentation. And welcome. Thank you for being here. And thank you for letting us use your facilities as well.
Thank you, Chair Wallen, and welcome, commissioners. Welcome to Nye County. I think it's awesome that you go around the state and visit different jurisdictions. So I wanted to tell you a little bit about Nye County. Director Armstrong has asked me not to make it wild, so I will keep it tame. Nye County is the 3rd largest county in the contiguous United States. We're right behind San Bernardino County in California and Coconino County in Arizona. We have a whopping 18,200 square miles. That's bigger than 9 entire states. And those states are Maryland, Vermont, New Hampshire, Massachusetts, New Jersey, Hawaii, Connecticut, Delaware, and Rhode Island. So our county is bigger than 9 separate states. So that's pretty huge. Within that large amount of space, we have several communities, the largest of which are Amargosa Valley, Beatty, Gabbs, Pahrump, Round Mountain, and Tonopah, which is also our county seat, which is where we are currently. Although we have a huge landmass, our population is not big at all. We have about 53,000 inhabitants, and most of which are down in Pahrump. Not only do we have proportionately small amount of residents, but we also have a pretty poor demographic. The average median income of Nye County is about $25,000 per person. So that presents a pretty unique challenge for us in county government. So we have a huge amount of land, very small population, and a very weak tax base. So it's very difficult to provide the services that we're required to provide. So the services that are important for our residents are roads, police protection, fire services, ambulance services, emergency management, water, sewer, animal control, and many others. So we do all of that with only about 450 employees. So that's quite a huge task. Normally we get things done pretty well, but occasionally we don't. And on one, I wanted to tell just a brief story about one time when we didn't. This happened in 2019, and around the summertime in about August, we received word of a Facebook post that somebody wanted to put together an event called Storm Area 51. So some of you might recall that event. All of you can laugh at it. At the time, we weren't laughing about it at all. So somebody had decided to put a post and somewhere, I don't remember what it was, I think they were on the East Coast, and they said, you know what, there are aliens in Area 51, which is within our county. And so let's go find them. They can't stop us all. So let's, who's in? So this started off as kind of a joke. It was dismissed at first. About 400 people viewed the post and responded to it. Well, after a couple of days, we had about 1 million people who not only looked at the post, but indicated that they were replying or that they were attending the event. So that obviously got us nervous and concerned. And so we started having meetings. What are we going to do? We don't have the infrastructure for this. We don't have enough fire protection. We don't have enough police protection. We don't have enough groceries in the store. We don't have enough gas in our fuel pumps to accommodate that many people. So we had several meetings and partnered with lots of different jurisdictions, but we saw how quickly we were going to be overwhelmed with this event that was supposed to take place a month later. Well, a month went by, the event date came, and fortunately only about 150 people came to the gates that were supposed to storm. We didn't have very much law enforcement involvement. We had, I think, one Dutch YouTuber who flew a drone over the gate into restricted airspace and was arrested. We seized the drone. Thank you very much to that YouTuber. We also had a couple of individuals who urinated on a fence, and so that they were arrested as well. And so, but other than that, we didn't have anything particularly big happen. But the big concern with it was that we had all of this traffic that was supposed to happen, and we ended up having, and we didn't think we were going to have enough resources to tackle the event. Ended up costing us about $36,000 for nothing, which was frustrating. But that day we realized how quickly we could be overwhelmed. And so we're grateful for what we're able to accomplish with the limited resources and the staff that we have. We're grateful for you all for being here. I wanted to put a big short plug in for your executive director, Ross Armstrong. He had a short stint here in Nye County for a while. He served as a deputy attorney general through the state, working specifically on the special victims cases. And then he made it to your illustrious board. I wanted to also do a personal note of thanks to this commission. So I don't know how many responses you get to the opinions that you issue and the work that you do. We had a case, and I won't go into detail, and it's already a case that's been resolved, so this isn't ex parte communications or anything. But we had a case involving a public official here in Nye County that was causing a lot of havoc for our staff generally and for me personally. It took some time for the case to get resolved, but eventually it was. And I think the outcome was fair and just, and it made me realize how difficult the work is that you have to deal with. You have a lot of politics that you deal with. You have a lot of interesting personality, a lot of really thorny issues that you have to deal with. But I wanted to thank you on behalf of Nye County for the work that you do, and appreciate you again being here. To help alleviate the struggling tax base that I mentioned earlier, please spend money when you go out. When you go out this road and back into town, past that first gas station, because that's in Esmeralda County, go to our gas stations, which are all along the road, and buy lunch here. And we hope you enjoy your time here. Thank you very much.
Thank you very much, Mr. Sutton. I appreciate it. And I have to tell you, I know of 2 people that spent a bunch of money at the Tonopah Trading Post. So they're doing their part. So one wanted some art and the other one wanted some turquoise. So they're doing their part, and we had dinner at the brewery the other night or last night, and we'll have lunch at the Mexican restaurant before we leave. So we're doing our part and stuff. And thank you for your presentation. I learned some more trivia. I love Nevada trivia. So now I can add that about Nye County being the third largest county in the country. It is a big county, that's for sure. So to my fellow commissioners, any questions that you may have of Mr. Sutton or comments? No? Okay. All right, well, thank you so much for coming and giving us your presentation, and the commission. Thanks to our executive director, he says he wants to go and do more outreach into the rural counties and stuff. And I think you have one planned for, is it June, I think?
Oh, for next year?
Yeah.
Yeah, we'll have a rural meeting next.
Yeah, so
year
we're
too.
going to just start getting out, because I think it's important, people need to see us instead of us just meeting in Reno, Carson, or Vegas and stuff. So we'll be around. So thank you. Right. Next item. Item 6 is our public workshop. Pursuant to NRS 233B.061, this is a workshop to solicit data, views, arguments, or other comments from interested persons regarding the commission's intent to adopt, amend, and repeal regulations set forth in NAC Chapter 281A. Possible action may include direction to the executive director to submit proposed language agreed upon during the workshop to the Legislative Council Bureau for drafting. At this time, we'll open it up for public comment again. Have we received any additional public comment, or are there members of the public here that wish to comment or on Zoom?
This is Executive Director Armstrong. We have members of the public on Zoom, but none have indicated they wish to make public comment at this time.
Okay. At this time, I would like for you to kind of present an overview of the process, please.
Sure, this is Executive Director Armstrong. At our last meeting, we talked about the state rulemaking process, which begins with a workshop, which is what we're doing today. Prior to that workshop, as an agency, we're required to do a small business impact statement and determine if any of our proposed regulations will have an impact on small business, because we only regulate government entities. We do not have an impact on small business. And so our impact statement is that there is no impact on small business on these regulations, because we just govern governments. And so the workshop is an opportunity to discuss language, to really mold what you want your regulations to look like. The next step after this workshop will be for me to then submit the language to the Legislative Council Bureau. They draft. Sometimes they have questions. It depends on how good your first draft is that you send in. And then when we get the official approved language from the LCB on potential new regulations, we'll have to hold a public hearing. And there are certain notice requirements for that. So I would imagine, depending on how many regulations they have going, that next, maybe at our March meeting, might be the public hearing for those regulations to adopt. Then they go to the Legislative Commission for a final review to make sure that they are consistent with legislative intent and are within the scope of the authority of our statutory authority to make regulations. So that's where we are in the process. In the materials on this item, you see the small business impact statement. There's a summary of the proposed changes and then actual language. And so, Madam Chair, I can go through that however you think might be most helpful for the commission.
Why don't you go ahead and go through the proposed changes, and I will open it up to my commissioners. If you want to ask questions as we go through each item, you can, instead of waiting until the end. Right. So proceed, please.
Okay, in the summary of changes document, you can see that there's really kind of three types of regulations that we have. Our statutory authority is limited to procedural items, and specifically they talk about complaints and advisory opinions. And so we have some administrative ones and then some ones related to complaints and advisory opinions. Luckily, in the actual statutory or the NAC language, they're broken out by topic. So if you are looking at the document that has the actual administrative code, I'll just walk through the potential changes and we can We can discuss those. The first occurs on page 6, and that is clarification of who the presiding officer is in a matter. There are certain motion determinations that the presiding officer makes. And so it just indicates that if it's not the chair, it's automatically the vice chair unless there's some other designated person. This happens if we have the chair sits on a review panel. Obviously, she can't hear the whole case if it goes to hearing, and so it's clear that the vice chair is the presiding officer. On page 7, a proposed change to 281A 100 is to change the definition of subject. And that is because the subject of a complaint is not always a public officer or a public employee. And so obviously we don't have jurisdiction over those individuals and those cases get dismissed. But if there's talking about things that a subject has the right to, we want to make sure it applies to all subjects, not just public officers and employees. And then moving on to page 10 of the statute, the language. The first one is just some cleanup language in 281A 177. Rather than like list out all the different determinations, just say, hey, make a determination. So it's to make that more efficient, easy to read language. And then in NAC 281A 180, duties of the executive director on page 11. What I'm proposing here is that the current regulation says that by the second meeting of the fiscal year, the annual report will be done. This just sets the October 31st deadline, which is typically when our second meeting is. But this year we had an unexpected meeting in July and then one in August. And so the entire process for the annual report was shortened. And so this just sets a date instead of saying, because if we have cases where if somebody demands essentially a demand for speedy trial for their adjudicatory hearing, we don't necessarily get to control when that hearing is. And so this makes it more consistent about when the annual report is due. And then on page 12, there's a recommendation to remove in NAC that the materials have to be in a week before. I think we should, while this process is going along, adopt a meeting policy that has that 1 week deadline. But one of the things that, as we get maybe more cases that are petitioned for judicial review, you miss any of these little procedural things and it can throw your case into disarray. So take it out of the NAC and just put it into policy. Makes sense. And then a new regulation that says the executive director shall establish and maintain policies. This would allow me the authority to make those like inter-office policies that are easy to do, and that the commission can also establish policies. But that way you don't have to look at every single policy we adopt. I'd still submit them and we'll probably have like a policy adoption policy that has them come to you, but a regulation that makes it clear that there's that authority.
So it might be something like when you do your executive director report, you could put that in there, that these are some new policies that it's for operation of the office or something.
Yeah, and when I first drafted this language, I had really convoluted language that was like, it shall go to the commission, and if the commission has an objection, they can pull it for things. Like, let's just put that in policy and have the authority for the executive director to put these forward. So those are administrative ones. And working with the staff, we also, if you go to page 13, there is this whole convoluted definition of a written document. And I think it was back when everything was paper, right? And it's like, this has to be on this particular document. Now we accept things via email. So again, more streamlining language in 281A 255. Again, on page 14, just consolidating. One of the governor's big pushes when he became governor was to make regulations more efficient. So we did that with that in mind. It's like, let's make our regulations more efficient. We received a waiver because there was all agencies had to, eliminate 10 regulations. We received a waiver to hit that first deadline for that, but I think it'd be greatly appreciated if we're able to say, look, here's where we're streamlining. It will help with the process. So oaths, that's one. It's the same thing. We can just say it in one sentence instead of two. So why not do that? On page 16, this is not going to be a wording change, but we have the weirdest thing in our regulation where we have a consanguinity and affinity chart in our regulation. The one that is currently in there is challenging to read in all sorts of colors. I guess I'm not sure if those colors are good for folks who are colorblind, if it gets confusing. And so we would propose a new chart that's maybe without colors, because the colors don't mean anything. I think they're just colorful, but a chart that's easier to read for folks within our NAC, so that people can understand that third degree of consanguinity that triggers a conflict of interest. On page 19, we get into advisory opinion regulations. As you know, we try to get advisory opinions done within 45 days. The biggest delay is when the commission council sends somebody proposed facts and questions, and then they'll never respond and never respond and never respond. And so then we have these cases hanging out there forever. This would say if they don't submit the information within 14 days, that the case is dismissed. We give them a deadline. It's a NAC. It's so an administrative regulation you as an agency can waive if you want to. And so there may be a super complex case. And Brandy says, or Ms. Jensen says, you really probably need 30 days to answer all these questions. Here's your deadline, but this just sets at the 14-day mark, unless we as the agency has waived that, then your advisory opinion goes away if you're not going to engage with us on that fact finding process.
A question on that one? Do you want questions now or do you want them at the end?
No, we want questions as we go through. I think it's easier.
Okay, thank you, Madam Chair. Executive Director Armstrong, just on that, would the person have to make a motion to get more than 14 days? Is that something the commission can grant or commission council can grant, or you can grant by without having to force them to make a motion? I'm just wondering whether we should address that type of situation in the language of the regulation itself, so that it doesn't actually require a formal motion if everyone's in agreement that more than 14 days is going to be required.
Yeah, that's a great question. This is Executive Director Armstrong. That could be an agreement between the commission council and the person that she's working with. There wouldn't have to be a formal motion. The advisory opinion process in the last several years has become less formal than it used to be. There used to be a hearing for every opinion, and there would be motions and notices of a hearing and all of that. Now there's so much that is just email communication between the commission council and the person requesting. So that would just be with the commission council. We could add language to the section that says that somebody can waive that 14 days via email to the commission council if that's, we can explore that language.
Yeah, I'm just concerned that it says shall issue an order dismissing the request. And if you have agreed to it, then maybe that should be a may, or maybe there should be other language that says unless otherwise agreed to.
Yeah, and Commission Council Jensen just noted she likes the may there in the last sentence. So that's a good one. On page 20 at the top, you'll see a green number 4. Again, this is advisory opinions. And this is maybe one of the more substantive changes that, most of this is procedural. This is somewhat substantive. We get in this weird situation that is inefficient, where someone is elected or they're appointed to some position and they can see an ethical issue on the horizon. And so they ask us for an advisory opinion and we say, oh, you haven't been sworn in. We can't help you at all. Like, come back in 30 days and file the same exact document. So this would say, for the purpose of advisory opinions only, we can consider someone who has been duly elected or appointed as a public officer or employee, even if they have not technically started their service. So this would say, like, if you are elected in November and you're sworn in on January 1st, you realize there's an ethical thing, you don't have to wait until March or April of your term to get an answer. We can get you an answer before you even start service. So that's what this number 4 is it just for advisory opinions extends the jurisdiction up a little bit.
I think this is one of the best changes to make, just because I experienced it myself when I became controller and I needed an advisory opinion, and before I could get in, I couldn't get one. So this is great.
Yeah, it's a unnecessary rigidity in how we interpret the law. And then again, you'll see that a similar 14-day language in 281A3 53. And so we can look for the same sort of may instead of shall on there. And then on 281A on page, sorry, jumping forward to page 24 of the document in 281A 375, that just indicates that we're getting rid of the word oral before the opinion and just say the commission council can be directed to prepare a written advisory opinion of an opinion rendered by the commission. Again, this flows. I think the word oral in there was from when we used to have hearings on each one. Now we don't. And so it could be an email, an email opinion direction instead of an oral opinion. So those are the changes for advisory opinions. Any questions on advisory opinions before we proceed?
Commissioner Scheer?
Thank you, Madam Chair. And just going back to the other 14-day, the 353. So just I'm just thinking ahead, if we change that to a may, because it says the request for an advisory opinion will be deemed withdrawn by the subject. We change that to may. I think that's going to require us to hold a hearing on it potentially. Because then the commission would have discretion unless we specifically put in there that the discretion is with the director. So just think about that as you're looking at the wording there. If we add a may there, because it's going to be a withdrawn, what it's going to require in terms of process. So yeah, that was my only comment. I'm just looking to see if that was going to make sense or create some kind of a more cumbersome process if we change that to may.
Yeah, because it that comment makes sense because we would need some sort of trigger for them to say, yes, it is withdrawn, where if we keep it as will. So to clarify, in 353, it's saying we issue, a request for supplemental information or a date, and here's your hearing, and they don't respond to that notice of hearing, then it's withdrawn at that time within that 14 days. So that basically be like, hey, we're setting a hearing for you. Please confirm you'll attend. This prevents the commission from having a hearing where it's just us sitting here. Right, and we don't really need a hearing, so we could keep that as will. So I'll note that.
Yeah, you might split those two. So there's a may on A and a will on B or something along those lines.
Yeah. Oh, that's a good idea. One of the other things that we've been talking about internally as a staff, and I don't know that we would need necessarily regulation, but the practice now is for every advisory opinion that you do, if the person doesn't waive confidentiality, we produce an abstract. And the way Commission Counsel Jensen and I read the statute is that if you direct us to do an abstract, we do an abstract, but we don't necessarily need to do one on every single advisory opinion. Now that we have, 40, 50 opinions a year, we have some that could be quicker and that abstract process on the back end, like what we'll have is in our opinions database is a bunch of opinions that say the exact same thing and are hard to navigate. And so I don't know that we need a regulation that says we don't have to do an abstract, but I can work with Commission Counsel Jensen on that to make sure we're within our statutory authority. I don't know if you have other thoughts on that.
Thank you, Chairwoman. Brandy Jensen, Commission Counsel for the record. In NAC 281A 375, the very last sentence says is used, or the number 5 says the commission will publish a copy of each advisory opinion, which is not confidential, and each abstract on the internet. And I think that's kind of the discussion is, well, and it could just be my inexperience with the regulations and using them on a daily basis, into the 3-month experience, but we are publishing every single time. And that's helpful when you don't have any case law or you don't have anything to go on. But when you have this many opinions, trying to navigate, even me as Commission Counsel, it's difficult to navigate to find the opinions that you're looking for. And so I think if we are only publishing, if we're changing a statement that we've made in a previous opinion, or we're change a matter of first impression, like those are the things I think should be published for guidance. Otherwise, I think it's kind of Time killer.
Yeah, and if you look up in that same regulation, that 281-375, 1C says may direct the commission council to prepare an abstract. And so I think that's where we have our ability. And so what you may see going forward, and again, I don't know that we need a NAC change because there's that permissive language in C, is commission hears an opinion. And if the person does not waive confidentiality, you'll see a request, kind of like a two-part request, like approve this opinion and agree with us that an advisory opinion is or isn't needed in this case. And so I imagine that's how that would look going forward.
I guess it's a bigger question, if I may. Do you want us publishing even the non-confidential ones every time? Because that makes more documents to sort through too. So I don't mean to raise such a big issue, but
Well, I guess my opinion on the non-confidential is that individual wants the public to know that it's okay for them to do whatever we told them to do. Instead of they have to go, they do something and then some member of the public files a complaint against them. And then, we've got all that. I think that the non-confidential ones should be published because it's not like we have to redact them or anything like that. That's my opinion. Other comments?
Madam Chair.
Yes, Commissioner Scherer.
I agree with what you just said. If they have asked for it to be public or waived confidentiality, then we should publish it. But I also agree with what Commission Counsel has said with regard to the confidential opinions, that unless it's a change from, if it's essentially identical to a prior opinion and there's no change in how the commission's interpreting the law, then there's no reason to do a new abstract or publish a new abstract unless either there's a change or it's, I think she said, it's a matter of first impression.
I would agree with that. Definitely.
That gives us the guidance that we need.
So
So
if I may, and I apologize, but the one other thing I might say is that I think you're right, Executive Director Armstrong, with regard to the permissive language in C and 375. But as long as we're making changes to the regulation anyway, should we just make it crystal clear in 5 and say each abstract created pursuant to this regulation or something like that? So there's no doubt about it.
yeah, we can add some language that and each abstract directed to be created by the commission or something to that nature, I think would help make it crystal clear.
I don't think it'd be worth doing if we weren't already amending the regulations, but as long as we're doing it anyway.
Yeah, I think that makes a lot of sense. This is Executive Director Armstrong again for the record. So we'll talk about complaints. The first change is on page 26 to 281A 405. And it allows, it gets so like super nerdy legal that it's kind of fun, but also it's probably mind numbing for other folks, is like, what is the definition of a complaint, right? And so what we are putting in here is that if this person submits a complaint and it's against someone, if it's against an entire agency, because we get that sometimes, they haven't identified any subject, or they refuse to sign it, because we get some that are signed like, anonymous or whatever they try to do, that's just considered a rejected complaint. It is not our definition of a complaint. You don't need to do a jurisdictional determination if the complaint is so defective in either of those two ways. And then it's just, that is a rejected complaint. And we would keep those stats as well for each year. So you would not see a jurisdictional recommendation if it's against an entire agency or they file it anonymously, because that's not permitted under our rules. So it would just be considered a rejected complaint.
And I can't remember because I reviewed this stuff a while back. We have something in here that if somebody has a complaint filed against them and they're not a public officer, that you can reject it. Is that further on, or is this?
We do not have that language. We would still do a jurisdictional determination on that for you. However, because that's a finding of fact, right, through your jurisdictional process. We did at our last meeting adopt those summary recommendations. That's just like a one-page recommendation instead of multiple. And that would be a situation we would use that shortened recommendation that says,
Okay,
this is not a public officer or employee.
okay.
Madam Chair.
Yes, Commissioner
Commissioner
Scheer.
Sheriff, for the record, just a legal nerd point. The word "be" is missing between "shall be rejected."
Got it. Thank you. And then and of course, this messes up all the numbering, but on the next page, on page 27, the one that is the green, the green number 3, it just clarifies that in preparing the recommendation for the commission, the executive director may obtain information through public records requests, conversations with witnesses and others, and any other means available to the general public in part of that preparation of the recommendation. We've had some folks say, like we asked for a public records request and they said, well, you can't do that until you have an actual investigation. We're like, no, this is available to the general public. And so this allows us to go through that. Makes it clear in the NAC that we have the authority to do whatever the public would be. We don't have subpoena power until you take jurisdiction and open investigation, those other tools to compel witnesses to speak, but anything the general public can do, we can do to help make sure the jurisdictional determination is solid.
And just to clarify, and I apologize for being new, you have that ability then to get more confidential information that may not be available to the general public in the course of an actual investigation once the determination is made to open a full investigation.
Correct. In the case that made me think we should put this in here, there was already counsel for the subject. They objected to the public records request based on our jurisdictional recommendation timeframes. It didn't make any sense to litigate it. And so we opened up the case. And we may have, if they had actually just been responsive, may have determined that we didn't need to open a case, that a letter was sufficient. But this would give us something to point to and say, you know, we can do these public things. If we need to get confidential information, then we need to have accepted jurisdiction and investigate. Yeah.
And this would also help when we have cases where we don't take it on because there's not quite enough information. So we dismiss it, but we've never gone forward to go and say, yes, this person did not have an ethics violation. It's just dismissed and hanging out there. So I think this is good for the person who has a complaint filed against them as well. It's fair, I think.
Yeah, my only concern was that this language not be read to limit what you could do once an investigation is opened and your ability to get other information that may not be available to the general public. But as long as you still have that, I'm comfortable.
Perfect. I'll note that too to double check. On page 29, so it's NAC 281A 410 talks about the notice of investigation to the subject. And the thing that we are removing from here is just the requirement that the waiver form go in, because what Associate Counsel Bassett and I have found is that the way we currently build that notice packet, so many subjects get confused. Then they have all these waivers and they feel like they're being asked to waive a bunch of rights. And so we can still provide these items, but it's not required to be in that notice packet, right? If we miss this in a notice packet now, someone can say, you missed your procedures. My whole case should be tossed out. This would just say, we're not going to mandate that the waivers go in that packet until you actually have that conversation with them about what that waiver means. On page 32 is the next one, and there's just this unnecessary language about who is issuing the scheduling orders, and this just says if a scheduling order has been issued, no matter who it is, that the same rules apply. And then in number 2, we noted that if the commission's going to and should be as well as established, there's another that if they're going to establish limits for oral argument in a hearing, that be part of that notice. I know that from the perspective of Associate Counsel Bassett and I, that's a practice we would like to see that hasn't traditionally occurred. But if there are going to be time limits, that be in that notice, because as we've approached some of our motion hearings, there's a lot of uncertainty about how much time we will have and what we should do in terms of that preparation. So if there's going to be a limit, to make sure that's clear in that document. In 281A 444 about discovery, I think Commission Counsel Jensen noticed that there was kind of a confusing referral back to a different NAC, and so changing it from provisions to procedures just makes it clear that all of those other items in 442 don't necessarily apply, but you follow the same procedural steps in there. And then in the rendering of the opinion in the matter was just additional language that could be streamlined. On page 35, again, just some modernization now that not everything is done by Pony Express, is to say that if the written request is filed, because it can be by email, it doesn't have to be at our actual physical office, that counts for the request. Skipping ahead to page 37 in NAC 281A 457, there's all this language in here that's just a copycat from the statute. And so we eliminated that so that we don't have to go back and change it if the statute changes, and just that a written notice of the adjudicatory hearing in the matter. I think it's just a period. And then the written notice must meet the requirements of 280. We can look at if there's a more elegant way to do that one, but it just got rid of that language that's already in the statute. That's already the requirement from the NAC. And we're almost there. And then again, in trying to be able to, do what other agencies have been asked to do. The last one is removal of NAC 281A 615 that says the acknowledgement form shall be available online. It's not one that we really need in NAC, because that's just a practice we do. And so it's kind of unnecessary requirement, I think. So that is the based on staff's looking at the NACs, the limits of our statutory authority. Those are the proposed changes. Now we can always, at a workshop, you can entertain all sorts of different ideas for us to take back. If the commission desires, we could always make additional changes and have an additional workshop, or we can take the edits that were discussed today and provide me with the authority to go submit it to LCB so they can start their drafting process. So I'll turn back over to you, Madam Chair.
Thank you, Executive Director Armstrong. I think that this is good. I like the streamlining. I like a lot of the changes that we put in here, because a lot of these things we're trying to actually fix in statute on our bill, which keeps languishing. So this is good that we can get some of these things done to help us be more efficient and stuff. So other comments from our commissioners? Commissioner Scheer, I really appreciate your observations and comments. It really adds a lot to what we're doing here. So thank you. Even though
Thank
you've only
you.
been a commissioner for a few days. So thank you very much.
I've done this drafting thing before.
Yes, I figured that. I know you said you're a policy wonk, so so thank you. Other
I did-
commissioners have, yes, go ahead.
I did have one other question, and I apologize for going back to 444, and this one I don't, because I'm, again, not as familiar with the current process. But in 444 subsection 4, this is on page 34. We've struck or in rendering an opinion in the matter. The only question I'd have there is can an opinion, and this is for a complaint type, the complaint process, because we've had discovery. Can an opinion be rendered without an adjudicatory hearing? In the complaint
Yes.
context. And if that's the case, do we want the person to be able to receive the evidence obtained during discovery?
For the I'm just working through, because this requires the executive director shall disclose evidence obtained in the investigation. that they intend to present as evidence for consideration by the commission at the adjudicatory hearing. The non-adjudicatory hearings that would result in an opinion would be a default proceeding. And similar to what we've done in where the parties waive the adjudicatory hearing and it's on motions, like we did in the Lombardo matter recently. And that we'll be doing early next year. So those, I don't know that in those cases you would need to disclose that evidence because there's not an evidentiary hearing so much, but I don't know. I don't know if Ms. Bassett or Ms. Jensen have thoughts about the need to disclose evidence if it's a hearing other than an adjudicatory one.
Associate Councilor Bassett.
A hearing other, I mean, we often do dispositive motion hearings, and in those cases, the evidence is included in the dispositive motions, and so I can't imagine. Well, if another attorney is going to try to bring in evidence outside of the dispositive motion, that would be a problem. So I would think that it would have to be disclosed before the hearing. It would need to be included as part of the motion. So I would feel it would need to be disclosed. Yes.
I guess just again, Commissioner Scherer, I would think that if there is going to be any kind of contested proceeding, even if it's on motions or if it's, purely on briefs, that there ought to be some disclosure of the evidence that the commission is going to rely upon, or that's going to be presented to the commission for consideration to the subject of the opinion, so that they can respond to that evidence. I mean, if it's obviously in the course of your investigation, there are going to be things you find, you say, yeah, that's not relevant one way or the other. So we're not going to rely on that. I'm not saying we should necessarily need to give them everything we find, but I'm thinking that there should be a right for the subject to have access to anything we're going to rely upon, or that you're going to present to the commission as part of the argument as to why the person did or didn't, again, even if they're cleared, they ought to be able to see the evidence that results in them being cleared.
So unstrike the language in 4.
That's what
The
I'm
safest.
thinking, but,
Yeah.
or change the language in another way. Like I said, I'm not familiar enough with the process, which is why I'm struggling a little bit here, but I would trust you to take a look at that and just decide whether it actually works for those situations where there's not a full adjudicatory hearing. And with the thought being that the subject ought to have access to the relevant evidence that's going to be considered in whatever the disposition is.
I concur with unstriking it. Just because I could see it being an issue.
I've noted that one.
And I'm sorry for missing that one as we went through that. That's all I have, Madam Chair.
Thank you.
Thank you.
So other comments from commissioners, observations? No? All right. I think this is, a good start. We've been talking about changing our NACs for, I think, 4 years now. So I'm glad we're finally getting around to it. So thank you to Executive Director Armstrong and staff for working very hard on this project. So thank you. All right, with that, I will entertain a motion to have the executive director submit the proposed language and revisions as discussed in this workshop to the NAC Chapter 281A to the Legislative Council Bureau for drafting. We hear a motion for this? Okay, do I have a second?
I'll second if no one else
All right,
jumping in.
thank you, thank you. All right, all those in favor say aye. Aye.
Aye.
Opposed? Motion carries. At this time, I would like to open it up for public comment again on this issue on item 6, our NAC discussion. Executive Director Armstrong, have you received any comments from the public since we started this?
We have, I will double check. There is nobody is indicating in the Zoom that they would like to
Hang on, I do have one.
have public comment.
We do have one individual of the public here. Yes. Please proceed and introduce yourself.
Thank you, Madam Chair, esteemed members. Nye County Commissioner Bruce Jabor. And I apologize for the process. I didn't realize you wanted us to address on each line item during. So I'm coming now because there was a little bit of confusion on my part. On page 12, bottom of page 12, number 1, Commissioner Policies and Procedures. Number 1, the Executive Director shall establish and maintain policies and procedures, et cetera. And however, with all due respect, Council or Executive Director, with your summary, you mentioned Executive Director would have the authority to make policy changes. And you're probably not able to, as we don't allow the banter back and forth or answering the questions. But it would seem to me that with the commission making the decisions and final determination on different complaints or violations, et cetera, that they would be the ones to make any policy changes and then give direction to the executive director to maintain those and such policies. Of course, this is my opinion, but it was a flag that that came up, unless the proposal is any such changes would be proposed at a future meeting for the commission to consider and then vote on, et cetera, to implement as part of their policy. Thank you very much.
Thank you very much. Any other comments? Members of the public? No one on Zoom? Oh, all right. Thank you. Thank you very much, Mr. Jabor. Appreciate it. I should say Commissioner Jabor, sorry. Next item, item 7. Consideration and approval of the Nevada Commission on Ethics Personnel Subcommittee's recommended revisions to the public service objectives, including performance priorities and job descriptions for the commission's 2 appointed positions of executive director held by Ross Armstrong and commission counsel held by Brandy Jensen. I want to note that this matter is to discuss the job descriptions and priorities only and not the performance of those holding the positions. Chair Wallen, Vice Chair Towler, and Commissioner Dufferin served on the committee, and we worked with the executive director and commission counsel to modify these documents. This item is bringing back to the commission the recommendations of your personnel subcommittee for your consideration and approval. The subcommittee actively met a couple of times during the past 2 months with both the executive director and commission counsel, and now presents for your consideration the updated job duties for each position, as well as a list of priorities in order of importance for both the executive director and commission counsel. As you can see from the materials, the subcommittee wanted the executive director to focus on the priorities of jurisdictional reviews, timeliness of complaint resolutions and investigations, and streamlining the operations of the commission. Likewise, for commission counsel, the subcommittee wanted her to focus on the top priorities of advisory opinions, ethics complaints, and litigation and commission meetings. And both have other priorities to address throughout the year as listed. At this time, before we have opened it up to the commissioner comments, I would like to ask the executive director if he has any comments he would like to make about this process and what we came up with for you guys to do.
Thank you, Madam Chair. This is Executive Director Armstrong. I appreciated the process and the engagement, especially the description. I think is always good, but really critical when you go to hire someone, right? So it's nice to have that that handy, though I don't anticipate you'd need it anytime soon.
I hope not.
And then the priorities, as you recall, I think when I began as executive director almost 2 years ago, one of the priorities was to like clear the case backlog, right? And that's done. And so that priority changes from clearing a backlog to preventing a new one from being created. And I think one of the things that we are asked for regularly when we go through our budget building process is a strategic plan. So I'm excited that that's one of the priorities, is to work on a strategic plan for the commission that we can take a look at those bigger items. We have a lot of work. This is one of the hardest working commissions I've interacted with in terms of just the number of cases that have to go through, the complaints and the advisory opinions. And so I think going through that strategic planning process will be great to get feedback from the commissioners on where we should be headed as an agency generally into the future as government service changes and as we experience new things going forward. So that's all I have as far as comments.
Commission Counsel Jensen, do you have some comments?
Thank you, Chairwoman. The priorities that are discussed here are very helpful as an employee to know what should be the priority to meet the expectations of the commission as your counsel. And the job description is helpful to know as a guiding document what to do based on some of my HR experience. These are invaluable tools for the employee to utilize as well as the commission. And I think one of the important changes was in the job description of noting that there is no direct staff for this position, and clarifying that was a great step.
Thank you. Now I will open it up to my fellow commissioners for any comments, observations, or any changes, additions that you would like to make to these documents. No? All right, I just have a few. I always do, right? Don't laugh. For the executive director under priority, we're doing priority education outreach. It's just a wordsmithing thing. Under number 43, item C, just it should be develop, publish, and update instead of develop and publish and update. So that's a little change there. And then that's all I have for executive director and commission counsel. I think I just have. The only thing I want to add is under commission counsel is customer service. Under this is in your job description, okay? Customer service, and I want to incorporate the same items that we have in the executive director's items number 2 and 3 under customer service. And let me get back up to that one. Page 6 on it, okay. Got too many documents here. Let me just read this. Thank you. Yeah, I would just, because we didn't have customer service on yours, and you have to provide customer service like our executive director. So I just want to add, ensure that all contacts with members of the public officers, and public employees are professional and respectful. And then item 3 under our executive directors is promptly respond to emails, correspondence, and phone messages. So just, and I mean, we just want to go and have that in there just because I think it's, and then, oh, I just have one more under the priorities. Priority number 4 is administrative efficiency, and just add existing case management system. It just ends at case management to optimize the existing case management. I think you mean system there. And then collaboration and update, okay, on a regular basis. Yes, so under item number 4, administrative efficiency, with the executive director to optimize the existing case management system. Just add system in there because it just sounds kind of funny. And that's it. That's all my changes that I have. No other comments? That's okay. All right. With that, I will entertain a motion to approve the recommendations of the Personnel Subcommittee including the job description, listed priorities for the executive director and commission council, including the minor changes that were added today. I'll entertain a motion for that.
I'll make a motion to approve. This is Commissioner Moran.
All right, thank you. Is there a second? Commissioner Lowry?
Commissioner Lowry, I'll second.
All right, all those in favor, say aye.
Aye.
Opposed? Motion carries. All right, moving along. Item number 8. Discussion, review, and possible action related to advisory opinions. Okay. Yes, sure. And what we're going to be doing is we're going to have a general overview and a presentation on our internal processes of advisory opinions. We're going to talk about the opinion formatting, possible action to direct our commission council to bring back to us our advisory opinion approach. So as she's getting set up here. No. Yeah, I think so. Sorry.
I think they're likely just to see the power.
Yeah, they'll just see the PowerPoint when they put up there, so. Doesn't matter now. Okay. All right, Commission Council Jensen, please make your presentation.
Would you guys like to wait for the PowerPoint or go ahead? Thank you. The Brandy Jensen Commission Council, for the record. It's been, so I looked, I'm actually at 3 months as of today, so we're past that 2-month mark. And it has been interesting to come from someone from the outside to coming into the inside to see how things work internally versus how they're viewed when you're in the external version of government from the Ethics Commission. And one of the things that was always wonderful from my position in a public position was being able to reach out to the Ethics Commission and say, we have this situation, how can we navigate this the best possible way? And it's wonderful that we have advisory opinions that other people can utilize and refer to and try to use as guidance. So whenever I say this is how I think we should do an advisory opinion, I fully expect the respect to be given of a 3-month person who has only earned the 3 months of respect, but at the same time, also the having been in the trenches and trying to navigate and utilize the document in the real life world. So it's kind of a catch-22. I wanted to go over some of the advisory opinion basics. I know we have a transition in commissioners, and I thought it would be just good. And it made me train myself as well as we went through all these things, just to remind myself on all the requirements. And so I think it's great for everyone to hear, and sorry if you already know some of the content, but it's still good information. We have what is an advisory opinion, and oh, thank you. It should say public officer or employee requests help on navigating ethics laws in Nevada, and the commission is providing guidance. And we're here to help them figure out to do what's right. And I thought that little quotation was great, do what's right, not what's easy. And that's sometimes the most difficult thing to try to convey to people, because we're looking for the fastest route. But it can be about past, present, or future conduct. And we do get requests for people saying things that don't fit into that category, which is kind of funny. It can only be for public officers and employees, can't be outside of that. And it can only be regarding our ethics laws. We have a 45-day time period to turn that around to the person requesting it. And there are certain provisions where open meeting law does not apply to what we do on these matters. Yes, sorry, I switched my mind. So the request for relief, so some people can reach out to the advisory opinion process and ask the commission to grant them relief. Strict relief from the cooling off requirements, which ironically we've discussed recently, and the contracting prohibitions. We're looking for them to ask for it before they get into the situation and the issues arisen. It is something that they can be permitted to share. So they can share it with their legal counsel. We can decide who they can share it to, so we can give them permission. But if they go beyond that and share it with somebody else, then they've lost that confidentiality. You can go to the next one for me. The advisory opinions are binding. So this was an interesting thing that I thought would be obvious, but it is interesting that it had to be put into law, that if the commission tells you to do something and then you don't follow that guidance, then that is what is going to get you into hot water. Oh, I think it's great that this next couple slides are going to really walk through how we do things, because some of the emails that I've received since starting have shown that this is probably not common knowledge. So in the first step is that somebody comes in and files a submission for a request for us. There's a jurisdiction determination between the executive director and I. The statute says that we'll consult with each other. And it is as simple as me shooting an email to the executive director saying, I do believe we have jurisdiction in this matter. Do you concur? You do surprisingly get quite a few that don't have anything to do with the ethics laws. Oh, that's an election issue. Oh, that's, some other type of issue that comes up. But because ethics is such a big subject, such a big topic, I think they think a lot of times the commission deals with a lot more than what they actually deal with. There's, after the jurisdictional determination, then a lot of times that's when we reach back out to the requester and, here's our facts, this is what we think is going on, or we need more facts. Can you please tell us these facts? Can you verify the facts that we think are right? And surprisingly, even after they've provided us information, when you turn around and kick it back in facts, sometimes people are like, well, no, that's not what I meant. What I meant was this and this and this is happening. And then once those final facts are approved, then we start going to the next step. And the next step is that we start researching the opinion. It's drafted. Obviously, that's commission counsel. That's who's putting those opinions together. And trying to look at previous opinions. We'll get into later how easy those are to access. Not quite as easy as I had hoped. I'm going to give you guys some homework when we're done to try to get in there and find a few things, and then see, sometimes it's a little difficult to navigate finding what you're looking for in that database. It is amazing that the database exists and that it is searchable by word. That's a fantastic improvement from when I first started in public government, and being able to actually at least search for cooling off or, something of that nature. Once the opinion's drafted, then it is sent out internally, both to the executive director and associate counsel for their opinions. And I can't tell you enough how much I appreciate staff being able to give their thoughts and opinions on these things. It has helped, especially the new person. Then once that's done, that final one, once it's, so before you guys see it, it has circulated internally and gone through everyone. And so when you're looking at it, it's already run through the executive director and associate counsel. The benefits of that are that, a lot of times associate counsel especially has dealt with a case and may have a particular input on something like, oh, this was an issue last time. Let's make sure we address X, Y, Z. And the executive director brings in the great advice from a bigger picture a lot of times as well on, oh, what about this, and think about that, and somebody else could take it this way. So that is then sent out to you for votes. That is not subject to open meeting law. And then everybody is done through an email. As you guys know, that email is sent back saying, I approve this, or I approve with changes, whatever those things may be. Once those matters are finalized, we kind of finish it up, make sure it looks accurate, double check it for typos, and then the opinion is issued. Thankfully for the guidance we received earlier, that would be that those are only published if it's a matter of first impression or changing previous law if it's an abstract. So we have to make a determination, is it an abstract or not? They let us know, and then we go from there. We already covered this for the importance of precedents and publishing only upon new issues or changed laws. The point of this, I think, is something that hopefully I can bring to the table for your awareness. these advisory opinions aren't written for us. They aren't written to try to catch people in some type of thing. It's a way to help somebody out in the public who is overwhelmed by the statutes and trying to navigate through them. And it's somebody who's trying to do the right thing. So the advisory opinion should be drafted to make it easy for someone to be able to utilize them and someone else in the future to also utilize that advisory opinion. Go to the next one from you, Ross. I thought this was the perfect picture to try to be able to see that, because sometimes it looks like I'm going to take the boat to the left because that just looks like the easy route, and the one on the right looks easier. But what they don't see is at the end of that clear one is a waterfall, and that is not the right path to take. But it looks easier and it looks like it's the right path. So sometimes it's not as obvious as we think. And there's this tug of war. When you research, I like to go down rabbit holes sometimes, and I researched ethics and the basis behind it and ethics laws. And one of the quotes was, it's a tug of war between self-interest and the greater good. And that is not the definition, right? Now, for most of us, we think, well, it's easy, greater good. But sometimes it's not quite as clear. We are biologically rooted to choose the easiest path. Time is a limited resource. And so sometimes it's not an intentional evil. It's well, that looks like the right path. I'm just gonna go over there. And that's not, or they don't think about it, right? They haven't thought it all the way through. And sometimes when they're reaching out for advisory opinions, some of the feelings I get is like, please be happy that I'm here. I know you're frustrated that I'm asking, but we're not, and so it's very important for us to make that clear in our themes and our customer service that we are happy you're here. And that's why each of the opinions I've sent to you so far have said they should be commended for reaching out. And that's in some of the previous opinions, that has been language used. Because I think it is, when you're a public official, even if that's in a million other opinions, reading that sentence and knowing that you're like, hey, good job reaching out to us before you act. There are issues where it's not quite as clear as we think, or even though it may be clear to some people, it's not clear to others. And it can be subjective and context dependent, making it a more complex process than you would actually anticipate. You will, please, Ross. And I think this is something that I don't want the commission to ever lose sight of. As commissioners, you've got to remember this advisory opinion has to go to someone who may have a lot of experience with the law and interpreting legal language or familiarity with it. And it may go to someone who's just looking for a 1-paragraph answer and they want to move on with their lives. And their experience, knowledge, training, all the things we talk about in law enforcement, right? Your KTE, your knowledge, training, and experience, it's going to affect what you're going to be able to navigate this thing with. And at the same time, we need to write something that can be upheld all the way to the Supreme Court. So it's a complex advisory opinion that we should be able to address and meet all of those goals of the commission. Are we making it so it's easy to use? Are we making it so it's defendable? Are we making it so it's well written and thorough and consistent with our prior precedent? So our goal, is it comprehensible and useful to all levels of knowledge, training, and experience? Or is it boring and I can't understand it? And what are our goals of the commission? And we have gone over some of those, so you can skip past that one. I think it would be helpful in some of these advisory opinions to have a summary at the beginning. Some of the things that we have in the advisory opinions could be put at the end or in appendixes, like disclosure, like how we have the language that says different facts could have something else. And, this is the commission considered this. There wasn't a meeting. Like when somebody's reading through some of those information, that's probably information that could be put towards the end that people don't really, but that's where we start. We start with the disclosures and so people are like already by the end of the first page, like, okay, get to the point. And I don't mean that in a disrespectful way. That's just, they want to start with where they need the information. So maybe that's where we start, is with a summary that gives them what they're looking for. Or maybe you think there should be some different language, and that's literally why I'm here. How can we make this, how can we improve it? From the outside, they're a little difficult to navigate, but I think this is a great team to be able to come up with some ideas. The precedent language in there is important. The language we use is all important. But how can we put it in a different format? So, and how are we making it easy and accessible? So, as a lawyer and a city attorney, I worked with quite a few lawyers from PullPact, and PullPact is a defense insurance group that works a number of the rural entities to defend different issues as they get sued. A lot of them are HR issues, a lot of them are ethical issues. And in some of the smaller towns, I think you see an even more increase in some of these complexities because the best example I have is nachos. So when I first started to work at the city, I went to sit down at the Mexican restaurant in town, and the guy comes out and he's like, I have free nachos for you. You're my favorite. No, I can't. I'm sorry. And 3 people I was sitting with were government employees and were like, why in the world are you turning down free nachos? And I'm like, why are they giving us the free nachos? Right. And so that becomes the question. And they're like, well, but you always get free nachos here. Yeah, but somebody that just saw me do that's not going to understand, and if you don't get free nachos here, why are they giving it to you now? Because now you work for the city. So I think that's kind of the helpful thought. Like in a small town, it's harder because what if it's my cousin that owns the Mexican restaurant and he's giving me free nachos because he loves me? So how do you navigate that? And it's really avoiding that appearance of impropriety and helping them navigate the ethical laws. If you can go to the next one for me. So it's how can we write it in a way that's helpful, but also understanding that your audience is a very different, varying audience of different levels, experience, understanding, and they're looking for the easiest path of an answer. And then there's people like us who love the complexity and want to read all the details, and we can put that after. So their executive director was kind enough to provide a bunch of samples, and you can look at some of those, or you can just kind of give me your thoughts on what you think has been working and hasn't working, and go from there.
Right. Thank you, Commission Council Jensen. Appreciated your presentation. When I was becoming controller, I actually asked the Ethics Commission for an advisory opinion about keeping my accounting practice. And the opinion I got was so convoluted, I didn't know if I could or couldn't. So I went to the AG's office and found out I could. I just didn't work at it. But I think my comments, having a simplified summary at the beginning written in English, not in legalese, would be great. I mean, I always harp on, like our annual report finally is in English, which I love. So I think that would be really helpful to the people, because not everyone out there is an attorney, contrary to what we think here, when most of the people in here are attorneys, except for 2 of us, I think, basically. And so I think that's good. I like your other little bullet point about listing topics for research. I'd like to see in our database, have opinions cooling off, disclosure, abstention, gifts, break it out by subject matter, because I think that would be helpful for people to research and to look and to get advice. I looked at some of the samples, okay. I kind of like the New York one, I want to say. Hang on, find out where'd it go. Had it here a minute ago. There it is. Yeah, I think I kind of like the New York one, seemed to be a little simplified. I think it was it. Let me look, hang on here. Or actually, I kind of like the Oregon one. That was kind of, the little summary there was pretty much written in legal or English with some examples, and I thought that was good. So, but I want to hear from my fellow commissioners on their comments and observations here. So, Vice Chair Teller, you have any comments?
Yeah, I went through those samples too. That was very helpful. I think, it's one thing to just say, okay, let's redo it. Let's make it simple. But I think it's good to see what other people have done. I also like the Oregon format. We talked, the presentation was helpful. I think it's a great tool, but like any tool, it needs to be fine tuned. And I think having easily searchable and having something that's responsive to the request and that's not going to confuse the requestor, I think is the key. And so however we get there, I think I definitely support revamping that, coming up with a new format and giving that a try.
other comments? Commissioner Lowry.
Thank you, Madam Chair. Thank you, Council, for your presentation. Much appreciated. I too like the idea of the summary in the beginning and making it as user-friendly as possible. I think that's a great idea, and agree with Commissioner or Vice Chair Towler's comments that engaging in this process and looking at the other examples and fine tuning our opinions, it's a good thing for us to do. So I agree with everything that I've heard so far. Thank you.
Any others? Observations? Commissioner Olson.
I also appreciate the presentation and agree with the terminology. Simple terminology. For not just us, but the average public out there reading it so they're not more confused after they read something.
Commissioner Jensen, or Commission Counsel Jensen, comments?
Thank you, Chairwoman. I think what I'll do is start to try to implement some of those changes into the advisory opinions that will be sent to you from this point forward, and then bring back a more formal format at a future meeting. And I will include this summary moving forward, as well as I think the important thing is to have a topic line item on each advisory opinion. So I'll include those as well as and a list of the statutes that are addressed, which I think is helpful. And then as you get those advisory opinions, they'll be a little bit more consistent with what we've been doing, hopefully. But if you see things like, oh, I think this is a great spot right here to change how we do that, or this should be moved here, I may move some things to the end, but they will still be in there. And then you guys can tell me whether you think that's a fluid format.
Yeah, and I think maybe what you title your summary would be like executive summary, because that's, people, that's what you read when you're have a big thick document. It's like, what's this summary? What's it? The gist of it, I think, is a good title for it and stuff. And so, thank you. So, I don't see any other comments, so I'll entertain a motion here to direct Commission Counsel Jensen to bring back a draft template. You want to bring back a draft template of an advisory opinion incorporating the items that we were discussed today. Do I have a second?
Second.
I guess I just made the motion, so what the heck? I made the motion, so is there a second? All
I'll
right.
second that
All right.
motion.
All those in favor say aye. Aye. Opposed?
Aye.
Motion carries. Right. Thank you very much for that. Now, our next item is our report by our Executive Director Armstrong on agency status and operations and possible direction thereon. Items to be discussed include, without limitation, education and outreach, budget update, staffing and recruitment, and our upcoming meetings. Executive Director Armstrong, please give us your presentation.
Okay, there we go. Thank you, Madam Chair. We had a short period between the last meeting and this meeting, so the report is brief because there has not been a lot of changes. I will say that in terms of education and outreach, I did train right after our last meeting, the International Code Council of Southern Nevada, it's always a great group to go speak to. I think there's usually about 125 folks there, so it's a good big training with folks at all different levels of government and some private folks too. So that's a good training that we got done. And then we have some upcoming training. I'll be training the Legislative Council Bureau next week, and then Commission Counsel Jensen and I will be going to the Kogel Conference at the beginning of December. We've been working internally on the manual. We have a design selected, and then we'll just kind of plow through the different topics to get that manual updated. It will have links to appropriate advisory opinions, the really good ones that folks need to know. And so that's another way to make that advice accessible, right? They have a question, look it up, and we link them to the really solid advisory opinions on those topics. The budget update, we're approaching the halfway point we'll likely need to do a work program for category 1, which is personnel. Some of that relates to the way that the cost of living adjustments were budgeted. They weren't necessarily fully paid for out of the base budget. They anticipated vacancies. And so if you didn't have enough vacancies to cover the increases, so there'll be some work programs towards the end of the fiscal year, but nothing too dramatic or wild that we're off track on in terms of the budget. The outreach and education specialist position has been approved by everybody that it needs to be approved by, and is now just waiting in line to get posted online so that we can accept resumes and go through that process. So I was hoping we would have it today. I just checked. It's not up there quite yet, but our number is right around the number they're starting to post. So we'll maybe there. And when I posted that, I requested that it be posted for 14 days. So a short posting period to collect applications and then move quickly to hire someone. So I'll keep you updated on that as we go forward. And then we have upcoming meetings. The 2 next ones, January will be in the Reno area and March will be in Las Vegas. Also attached are proposed 2024 meetings with a meeting in January, March, April, June, August, October, and November. And you can see the proposed locations. One of those, and we have the proposed to have the June meeting be in our rural meeting. So we'll pick a site as we get closer to that for our rural meeting. And then I put some potential topics on each one. Those can obviously shift. One thing to note, and we talked about it previously in the meeting, is based on the timing of some cases, if we have someone that's going to an adjudicatory hearing and they invoke their right to have the hearing within 60 days, that could always make us put a meeting on a day that's not listed here. But I wanted to make sure that these dates looked good for folks as we start to plan 2024. And that's the conclusion of my report. I'm happy to answer any questions.
Commissioners, any comments? Yes, Commissioner Lowry.
Thank you, Madam Chair. Mr. Executive Director, what do you mean when you refer to work programs in relation to the salary budgets?
So thank you, Commissioner Lowry. I am a creature of the state. So I just say words that I assume everybody else knows, but a work program is a technical budget tool that is used in state budgets to move funding from one category to another, or to pull from a contingency account into the budget. So it means that you're just shifting money among your budget accounts or pulling out of a reserve account if necessary. So they're very aware of the salary ones that will need to occur. We'll have to work program all of our own money into our salaries first before we dip into any of the contingency funds that have been there.
Okay, thank you. And what is the exact title again of our newest position that's going to post?
It is an outreach and education. The state title is officer, but I think we'll call them a specialist. We can play with that a little bit, what we'll actually call them by title. But the formal state title is outreach and education officer.
Thank you.
And sorry, Madam Chair, if I can, I just I did want to note that, we're gonna go to Winnemucca. We ended up in Tonopah. As Mr. Sutton indicated, that's where I cut my teeth and started my career in public service. And so it's always great to be back in Nye County. I won my first jury trial in this building, actually, long ago now. But I know that I kind of proposed hey, we should go out to the rurals, and someone was, oh, we're going to the rurals. But I think it was great. It was great to get the information from Mr. Sutton today. And so I appreciate everyone's effort. It's a lot of logistics. So I appreciate the staff and helping make the Tonopah meeting a reality. And I'm excited to see where we'll head next year.
Thank you, Executive Director Armstrong. Appreciate your report. I vote for Winnemucca next time. Go to the Martin Hotel for dinner. I enjoy going around to the rurals. I love Nevada, so I like doing that. Any other comments from our commissioners? Yes.
Thank you. I just want to thank Mr. Armstrong for using a term work programs. Finally threw out there and used at least one. Ms. Lowry.
Thank you. All right. Not seeing any other comments or questions for our executive director. I'll entertain a motion to approve his report as presented.
Thank you.
All
I'll make that motion.
right.
Commissioner Olson.
Is there a second?
I'll second the motion.
Okay. All right. All those in favor say aye.
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 Opposed? Motion carries. Next item. Item 10, Commissioner comments on matters including without limitation, identification of future agenda items, upcoming meeting dates, and meeting procedures. There's no action that will be taken under this item. So commissioners, do you have any comments that you would like to add? Observations? I just want to again welcome our newest commissioner, Shear, to the commission. I really appreciated your input today when we were talking about the NACs and your other inputs. So thank you very much for your participation and being here. And we look forward to meeting you in person in January up north. So thank you very
Look
much.
forward to it as well.
Yeah.
Madam Chair?
Yes, Commissioner Moran.
Yes, thank you, Madam Chair. Again, same thoughts I'd like to just echo with regards to the newest commissioner and welcoming Scott to the board. I think he will obviously be an asset, big value add to the commission. It's nice to see that this commission continue to flourish with some really, best and brightest, legal mind related, knowing landscape, knowing the people, knowing the state intimately. I've had an opportunity to work with Scott, both as a practicing lawyer, appearing in front of him when he sat on the gaming control board. He was a delight to deal with, had great bedside manner. His door was always open. I'm sure he'll be implementing the same strategy in terms of how he handles himself as a board member. And so again, I've worked with him professionally side by side on, as private counsel representing clients before different boards and tribunals throughout the state. So I will say, as it relates to Scott, great appointment by the governor. And again, looking forward to, or Scott, your appointment was by the governor or was it by the legislature?
This time around by the governor, yes.
Okay, terrific. Well, I'll look forward to working with you as well. And it's good to see you too. Thank you, Madam Chair.
Thank you.
Thank you, Commissioner Moran. And then as always, I just always want to thank staff and Commission Counsel Jensen. This was a good meeting. We had a lot of stuff to cover here and, nothing like joining us and having lots of stuff going on besides just advisory opinions. And I want to thank our chauffeur, Terry, for getting us Northerners down to Tonopah. And I'll let you know how Executive Director Armstrong does to get me down to Vegas. So anyways, but thank you to the staff as always for everything that you do and putting these meetings together. I know it's a lot of work. So with that, I will go and next item is public comment. Executive Director Armstrong, have we received any additional public comment?
Madam Chair, there's no longer anyone from the public on the Zoom, and we have not received any email public comment during the meeting.
Commissioner, please proceed.
Thank you, Madam Chair. Bruce Jabbour, Jabbour. I take some great things away from today. Your meeting is entirely different than our meetings. And we were just here yesterday from 10 to 7 p.m. I'd like to share with you, Counselor, I've never been offered nachos. However, I will share with all of you that I was at a banquet in the South, and I was approached by a lobbyist, also an attorney, He introduced himself to me. And he said, Commissioner, I understand that you won't accept anybody's campaign contributions. And I said, that is correct. I'm self-funded. However, I graciously thank you and anybody else who offers, but I don't accept any gifts. I don't accept any dinners, etc. But thank you anyway. And he said to me, but then I'm of no use to my clients. And I said, sir, that's exactly why I won't accept anybody's offer. And so that really hit home with me. Your presentation, the whole meeting, actually, it's very good. And I wish that more people attended. Manager Sutton did inform me last week that you would be here at the invitation of your executive director, and welcome back and welcome to Tonopah. There really is a lot to do here. And hopefully you have some type of guided tour. The rurals, so very important to the state, to the success. Of course, we don't have the population of the South and the North. I spent some time in Carson, not incarcerated, but in Carson City. My background is hospitality gaming. And I'm also the vice chair for Nevada Silver Trails, a division of Travel Nevada and NCOT. And we have an annual tourism meeting, the state meeting, and we choose a different spot throughout the state. I think during COVID, 3 years, we had to cancel Virginia City, unfortunately, and hopefully we'll get back up there. But again, the roles are so very, very important, and I'm not sure if you want to advertise more to get more involvement from the other commissioners, and of course, you are welcome to stop at Love's and patron our neighbor, Esmeralda County. They're right on the border, and just north is Mineral County. So we are neighbors, and we all try to work together. We do work together, and I appreciate each and every one of you, new or old on the board, for what you do, because we've seen in writing some of the decisions. We've seen in writing just in our backyard some of the complaints, et cetera. So thank you for doing what's right and not what's easy. Thank you again.
Thank you. Thank you very much, Mr. DeBoer. Thank you for your comments. We really appreciate it. And we enjoyed being here. All right, with that, there's no other people on Zoom that want to make public comment? Okay. All right, with that, I will entertain a motion to adjourn.
So moved.
All right, is there a second? Gotta put your mic on.
I'll second that.
All right, all those in favor say aye.
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 Opposed? Motion carries. Well, thank you very much, everybody. Have a happy Thanksgiving, happy holidays, and I guess we'll see each other next year. So, all right, bye-bye.